Good morning. This is Tracy Cotton with Morrow Insurance Agency, and I am going to be giving out this week a set of 5 different days worth of agritourism tips. These actually are going to all revolve around insurance and risk management as it pertains to agritourism. That's something that I thought would be kind of fun leading up to the fact that I am going to be presenting as part of a panel on Saturday at the 2017 Appalachian Sustainable Agriculture Project, otherwise known as ASAP's, Business of Farming Conference on Saturday at AB Tech here in Asheville. So with that in mind, I thought that would be kind of fun to post up a series of tips leading up to that day, and then something that's actually also you can refer back to for those who actually go to the conference. They can come back and watch any of this video series because they may have not actually didn't have the opportunity to go to the session within the conference. And it's just going to be a panel, so I'll be answering questions in it and won't be given a strict presentation. And that's the other reason why I wanted to talk a little bit about some of the, I won't say tips and tricks, but definitely some information that I really wanted to share about what is agritourism and what does it mean to insurance? How is it different than regular farm insurance? And what exactly it is that, as a farmer who wants to participate in agritourism and benefit from it, what is it that you need to be aware of? And so the first thing I wanted to talk to today is, because I'm here in North Carolina, but we're not the only state that has this particular type of statute, I wanted to talk to you about this big thing right here. It's kind of hard to see because this is my tablet that we're recording on today. But this is actually something that came out back in 2005 from a session law from the House and General Assembly of North Carolina. And it regards agritourism activity liability. A lot of times people call it the Agritourism Liability Law, the Agritourism Warning. It is an act to limit liability arising from certain agritourism activities. And as you'll see, it's this whole page right here, plus more. It was signed off by the governor back during that time period. The lighting in here is really kind of difficult to see with the camera. But it's a lot of words, and you're probably wondering, like, what does all that mean? Well, I can tell you what it all means in just a really short explanation. All this really means is the same as what's on this coffee cup. Caution, contents may be hot. This is a refillable coffee mug, but it's very similar to the same ones that McDonald's uses. And McDonald's didn't start putting that information on their coffee mug until back in the 80s, when they had the lawsuit where the woman had been very badly burned by some hot coffee. If you're like me, you probably want your coffee to be hot when you want it hot. Needless to say, there's folks out there that like it iced, or they like frappes with it all blended in. But for most of us, if we're going to have hot coffee, we're expecting it to be hot. But what that did right there, by putting that on the coffee pot, the coffee cups, was it elevated that expectation so that anybody who saw those coffee cups would know to be careful. Because if the top came off, you might end up burning yourself. But what it didn't do is it still didn't keep, and it doesn't keep, McDonald's or anybody else that serves hot coffee or hot beverages, etc., from possibly being liable from their own activities. And so what I'm trying to say here is this statute, which North Carolina's not the only one that has this. Louisiana has one that's almost exactly, it's almost word for word the same. What it really is trying to do is to hopefully let people know, if they're coming onto your farm, that it's dangerous, that it's actually something that they need to be concerned about. They need to be cautious about, because there's certain hazards, wild and domestic animals, ordinary dangers of structures and equipment ordinarily used in farming and ranching operations. There's inherent risk. So by coming onto your farm, they need to be aware of the risk. With that, though, by letting them know that they are coming onto your farm and getting that risk, it does give you a little bit of protection. It protects so that they can't say, I came onto your farm and I hurt myself really badly and I'm going to sue you now. Well, was it their own negligence? Was it the fact that there was nothing you could have done to prevent it? Was it the fact that it was inherent to just being there? Standing on top of a ridge and getting struck by lightning would be something that you wouldn't actually be able to prevent them from happening to them. But does that mean that this keeps you from being held liable for having agritourism, for having people on your farm? It does not. It actually means that you still could be held liable. And one of the things that's interesting is the way that it's worded in some places is that if someone still gets hurt because of your willful or wanton disregard for their safety, that you could still be held liable. It's actually in here. If you forget to tell them they need to strap themselves in before they decide to go on a zip line across your pond, which that's not going to happen. But you see what I'm saying? The expectation is that you're still going to do everything you can to protect them from themselves by putting up warning signs, from locking up the most dangerous of tools, from hopefully making sure that any activity that you're going to have them participating in, that there's adequate supervision and trained personnel that can actually help mitigate the possibility of injury or death. An example that I know of is a farm that has a jumping pillow, which it's kind of a controversial thing. A lot of farms are really considering it because it could be something that could add a nice attraction. The cost is reasonable enough, and it's something that could be added, could add actually a way to make money. But it's like a giant trampoline, and to most insurance carriers in general, trampolines are considered to be hazardous. So there's that little bit of a disconnect there. But just to give you an example of something that can happen is at this particular farm, they normally had somebody who was right there when anybody was going to be on the jumping pillow, an actual employee of the farm, so that if someone was going to be getting on it, that they weren't going to be acting all the fool. And unfortunately, there were no employees present, and a participant, a visitor to the farm, who was jumping on the jumping pillow, ended up breaking an arm. There was some expectation that the farm ownership should be providing some supervision because it is an activity that really requires a little bit of extra help to keep people from hurting themselves. The same with lots and lots of other things. And we'll talk more about this week. We're going to talk some specifics of what you can actually do, where you can put signs, what you can actually do to try to keep people from hurting themselves. But I wanted to start out just with this because this is something that a lot of farmers think, well, if I put these signs up, then I'm home free. And that's not the case. You still can be held liable. And we'll talk more about whether or not your farm policy actually anticipates agritourism or not. Meanwhile, I hope you have a good rest of the day, and I look forward to talking to you again soon. Y'all take care.